There. Good morning. Welcome to Sunrise Daily. I'm Chamberlain Oso.
Just to remind you, it's day 5.
Of what?
January. Am I Makinde? Good morning. Good morning and welcome.
I thought you were going to say day 5 on some sort of probe or some committee or something happening somewhere.
Well, day closer to AFCON matches, so yeah.
Okay, you know you can get me with that one. All right, no problem. Closer to AFCON matches, not that the matches have started. Okay, all right. Well, you know, security is always a big issue, not just here, I mean globally. If anywhere isn't secured, you know that investment or thing just cannot sit right. And we've been grappling with some of these challenges for a long while. There's been different suggestions and commentary as to, yes, we all agree we have a problem, but how do we address that problem? We don't seem to be on the same page. Look, not that it is not right for us not to be on the same page. Of course, ideas have got to contend, and then the superior ones have the day. But in this case, since it has to do with a constitutional matter, the law will have to kick in at some point. And it takes us to that question, the big question, state police. So there you go. Is it because they call it state police, or do we call it reorganization of the police force? So perhaps if we use that word, I think people even understand that, yes, when they talk about state police, it means reorganizing our security architecture, particularly when it comes to policing, you know, giving them their pride of place and ensuring that certain things go right. But they can choose to understand it whichever way they want. But then, we know the VP has spoken up about this. We know several governors have spoken up about this. Ministers have spoken up about this. But the latest commentary, well, the president, even though he has spoken about this some years ago, but now he's also speaking about state police.
Well, it's an exclusive conversation Channels Television had with him. So what's he saying about state police? We'll take a listen first.
Well, you see, the role of traditional rulers must not be undermined, because in their areas, as I said, they know who is who, even by families, not even talk of individuals. So we have to revert to that system for us to have an effective security in the localities. For example, there were 2 governors that came to see me about problem, Oyo State and one other state. I said, because the herders were in their forests, but the animals were going into the neighboring farms and eat the crop. I said, as far as I know, the farmers and the herders have been coexisting in Nigeria. Let them go and ask the local leadership what has gone wrong, why the break in communication between the local leadership and the herders that come on seasonal basis, the route they follow, the forest they confine themselves to. Why are they now extending into the farms of people? I just sent them back because these things haven't been happening this year or last year or 10 years ago. For generations, people have been living like that.
So the state policing is not an option?
No, state police is not an option. Now, find out now the relationship between local government and the governors. Are they getting, in the 3rd tier of government, are they getting what they are supposed to get constitutionally? Are they getting it? Try and see those people from local government that have confidence in you to tell you the truth, the fighting between local government and the governors.
So that's what the president's position is.
Not that it's a new position.
No, not that it's a new position.
He maintained that position in 2018 as well, when he also spoke about that matter. And he says almost the same thing, that look at the states. We give them bailouts. That how could you train people, give them guns, and not pay them? Or are you going to place that, quote unquote, it comes across as a burden to those states who were giving bailout to pay salaries? Where would they get resources to fund those. And he says, rather than, and then he spoke about recruitment, saying that, look, he thinks that, yes, he's told them to recruit about 6,000 or thereabout, and then increase funding for them, but that they should not just go to the market and pick, or rather than go to the market and pick just anybody, they should recruit across 774 local government areas. But there's a big question to all of that, because the last, I think the 8th Senate, the governors and the Senate at that time, the National Assembly, they spoke about the same matter. And then some of them said, look, we know that there are some states that can't afford this, but if there are states who think they can, let them go with it. Then there can always be that conversation and the solution as to, okay, if states cannot afford it and they want to, how do we go about all of those? So those were all conversations that were in the offing. But even at that time, 2 years ago, the president also did say, look, I support the Constitution. If the Constitution says yes, then it's yes. If it says no, then it's no.
So it's back into the quote of the National Assembly.
No, but of course, you know how we work here. If the number one man is not supporting that matter, it's going to be difficult
I think
for National Assembly to go contrary.
Yeah, I get that. But I think one of the issues that, if I understand correctly, what the president is saying in this interview. By the way, you will listen to the full interview at 7 p.m. tonight on Channels Television. You can watch it, and I'm pretty sure it's going to be on our YouTube channel subsequently. I think the issue the president is raising here is we haven't explored all available options.
What are the all available options?
There is something that he said that several other people have said over time. I think, I don't recall correctly, but I think it's something that former President Obasanjo has also referenced. And that's the fact that, look, we had a traditional system work effectively in time past. Many of these people who live in these localities have lived there for a very long time. What are the things that we did then that we stopped doing? Don't forget, Chamberlain, one of the issues that we have raised over and over again on this program is, okay, for instance, we are having all kinds of incursion from different parts of other countries. And we have local governments, we have communities, and we say there are people coming from outside Nigeria. How come we are not having those conversations? How come we are not having those conversations with the communities in order for them to also stave off the incursion from people all over, from other countries into the country? So those conversations are very, very important for us to have. The issue of traditional rulers, he said we should question the local authorities. Okay, so what are those collusions? What are those things that we were doing before that we are not doing anymore?
Well, you know, when...
So my apologies, Chamberlain. Yeah. When you talk about us reorganizing our security architecture, exactly what are we talking about? Are we only talking about the military or armed forces? Not necessarily.
No. It has to be local first.
Exactly.
The military is to protect Nigeria against external aggression.
Exactly.
Protect the territorial integrity of the country.
So all those customs, immigration and all those ones that are in all the border points in the country.
The revenue-making agencies?
The revenue-making agencies who are supposed to ensure that no contraband comes into the country in the first place, which we find in a market in Ibadan and everywhere, and they say that they're going to look for the contrabands. How did they get there in the first place? It means that some people were not doing their jobs. So if we are talking about reorganizing or rearranging the security architecture, yes, there's a role for local communities, local authorities, and all of that. But those federal authorities that are supposed to do some things, which find themselves into the country, who is asking them questions? So it's, in my opinion, what the president is saying is a lot more than just talking to traditional rulers.
Yeah, because look, right now, can we get solutions as presently constituted? Are we getting solutions as presently constituted? I guess that you can see the answer right there.
Absolutely.
So if this is not an option, what is the option? Recruit across local government areas, give them more money, but states, no, you can't handle this because it's too much for you. Will the states think that way? Because some of them think we could do a lot better. Some of them have capacity to. So are we going to say because of those who don't, then those who can shouldn't?
The issues are varied. For instance, look at what happened yesterday between Governor Sanwo-Olu and some DSP or CSP in the Magodo land tussle. We're probably going to have a little conversation around that later. And the man said he came from Abuja on the orders of the IGP and the AGF, and that a governor, CSO of the state, cannot ask him to go out.
We'll get a legal perspective on that
Most
and put it
certainly.
in that perspective. But, you know, remember the VP also did say, look, we cannot police a country the size of Nigeria centrally from Abuja. Several other people have done. So clearly you can see that they may not be on the same page. So, but what is wrong in, you know, us as a country having a conversation about all of these things?
I think there's something that you often say that let ideas contend.
Yep.
Well, don't forget you can watch this program at 7 p.m. tonight. The exclusive interview with the president tonight. That's it right on your screen, and it is going to be on the station, and subsequently you'll be able to see it on our YouTube channel.
Yeah, and don't forget, go ahead and send us your comments when they talk about state police. And that also means federal, state, local government. In some countries, they
Absolutely.
have different structure. So even what the president is saying about local government, yes, it can be factored into state police.
Absolutely.
So when they call it state police, they need to let those who are calling it such properly define what they mean. It doesn't just mean the states will have the police, no more federal policing structure. No, you still will have all those cadre and levels of policing. So let's know what you think about some of these matters. I mean, that's what this is all about. Let your ideas come forward and let's see, who knows, if somebody needs to get a better understanding of all of these things. So that said, let's go ahead and take you through some of the dailies this morning. Do we start with leadership newspapers?
Oh, well, quite a few.
Okay.
Let's go with the leadership newspaper first of all. And of course, we are talking about, well, some say this 2023 is the political year.
Oh.
2023 is the election year.
Well,
that's
some
what you-
elections will happen.
Oh,
but
yeah.
the main election.
Well, when we talk about elections in Nigeria, of course, we are not talking about this. What do we call them? Small elections? Please, don't even go there.
Small elections?
Leadership newspaper this morning.
These are elections that produce governors.
Excuse me, I'm reading, leadership newspaper. That's it on the screen.
And you glossed
Ahead
over...
Ahead of election year, states prioritize capital projects in 2022 budgets. The budget is still going to be in the news for quite a while, but you have that on page 4. Experts foresee boom in economic activities, warn against white elephant projects, hinge successful implementation on unstable federal allocations and political will. Uh-oh. Did you see that? They hinge successful implementation on stable federal allocations. That's the states, according to the leadership newspaper this morning. Well, the details you find on page 4 of the paper this morning. And right under the pictures you see on the front page, FG gets U.S. nod to fight bandits with Super Tucano jets. The details you find on page...
Before or after designation of those, terrorists, bandits as terrorists.
I'm even wondering what that means. I thought we paid for it. Is it a gift?
You could even see how I'm starting to be stumbling over all of these things because we make it difficult for ourselves in this part of the world. Something as simple and as straightforward, we all just like to go around in circles and play the ostrich. Let's call a spade, please. It's not an agricultural implement sometimes.
Isn't it an agricultural implement?
Spade is a spade, please. The Guardian. Let's take a look at that one next. Barely 1 year to go. Buhari appoints economic advisor. Could that be part of the reasons why experts perceive boom or foresee boom, as that paper said?
Experts foresee boom from at the states.
Oh, at the states.
Because of disbursement for capital projects.
Okay. And then you see this, the writer, Zaka, appointment is vote of no confidence on NEC. Well, Salame's economic thoughts at variance with president's philosophy, says Donri. Oh, okay. You may want to just go ahead and see that and see what happens with that one. That's the Guardian today.
Well, interesting, but perspective there. Oh, don't also forget on the front page of the same Guardian you find that story. France alerts world to new COVID-19 variant. What's that?
Well, they need to actually read it properly so that they can see in that context if what stage and what exactly is happening. So, is it the same scenario as SA alerted the world and things like that? So,
Daily Trust newspaper has this one: 5 bills that will shape economy this year. Which are those? You may want to find out on the inside pages, page 5 to be precise. New laws to replace archaic provisions in Customs Act and others. And there is a statement that's like a quote. You'll find out who said it. Government can't borrow more for critical reforms. Find the details of that on the inside pages of the paper this morning and several others on the front page of the paper. Oh, there's this other one. Declaration of bandits as terrorists to be gazetted. That's ascribed to the federal government. The story is on page 19. So I guess, should we say it's a done deal? Don't also forget the daily count that Daily Trust is having. Federal Government College, bringing Yori, the children, school children in captivity, still in captivity 204 days after. And Bethel Baptist High School, Kujama, 186 days after.
Look at Daily Independent next. FG's auto gas policy hits the rocks, may threaten deregulation. I know. It feels like that, doesn't it?
We have, you remember that policy in the wake of COVID-19? I forgot the name of it now. It's a stimulus kind of package from the presidency. In it is that gas implementation project all over the nation. And if this, okay, I don't know. Remember that we were supposed to have this auto gas as an alternative to PMS. And is that the one that's hitting the rocks?
Devil is in the detail, they say. Look at what's beneath that lead story at the bottom strip. Why we are yet to declare bandits as terrorists. Ascribed to the FG. I know sports people say, just do it. You know what that says. That's Daily Independence this morning.
And on the front page of the Nigeria News Direct, shake-up in Nigerian Air Force. Stories on page 3. As CAS appoints new branch chiefs, AOCs and others. Appointment, morale booster for officers, ascribed to experts. Deployment to assist CAS to achieve vision, says Adamu. The details you find on page 3 of the paper this morning. Right above the nameplate, 2023 presidency, 100 bishops, other Christian clerics to hold 3-day prayer for Governor Yahaya Bello. Stories on page 3 of the paper this morning.
Okay, so take a look at Vanguard newspaper today. Magodo land tussle. Drama as police from Abuja defy Sanwo-Olu's quit order. Quite a host of writers. Governor Sanwo-Olu says, call your superiors in Abuja. Tell them I want you to disengage right now. Then police CSP responds, you can call them yourself, sir. I am too low or too small to call them. And Sanwo-Olu summons Magodo stakeholders meeting. There is need for true federalism. Information Commissioner. Residents continue protests. Look, one thing that sticks out like a sore thumb here is, well, people always say they're going to abuse the police. They're going to abuse the police if you give them state police. How about this?
Exactly.
And then some say, well, if we're not at the same party at the center, things will go well. How about this? They're supposed to be on the same page, isn't it? You expect.
It's a very interesting conundrum.
Yeah, and then insecurity, anticlimax as Imo governor fails to name sponsors. So it turns out that after all the quote-unquote build-up, made everybody look forward to it, and then it said, let the police investigate it. Didn't you know the police was going to do? They were investigating it way before all of that hype. So what was all the hype about in the first instance? So sometimes you just wonder what politicians take.
Or was it what Governor Akeredolu calls political gunshots?
Well, that just political gunshots. That sounded like political catapult. Not political gunshot, because that didn't. They said, no, let the police do that. Of course, the police was going to. They said they were doing their jobs in the first place. I don't forget some of the backstory. And then they thought, look, if you arrest them and say these are the sponsors of the, unknown gunmen, what about the narrative that the police had put out? That it's IPOP that's responsible for this, not unknown gunmen. So this was going to upset the apple cart. And so, all of those you hear back and forth. So now, would anybody take him seriously now if he says, I'm going to name some of these things in the future?
He's the governor.
Look at what's at the bottom strip now. Failure to declare bandits terrorists, Malami's reasons not tenable. Afenifere, Middle Belt Forum, Ohanese, Pandef. So all put together saying that. Well, there's your Mr. and Mrs. here. I don't know if you want to do the honors, because I can't see clearly now, I must admit.
All of a sudden?
No, not all of a sudden. The text is a little blurry.
It's hard paper in your hands, bro.
I know, but it's still a bit woolly. If you take a look at it, maybe you might agree with me. You never can tell. I mean, I need a second opinion, because it's my word against who now. So it's one-on-one. And there's no dividing factor here, so I guess it has to go that way.
We'll bring our protest to your house. We'll bring Lekki Toll Gate to your house.
Or flip to the back page and see what's on Vanguard Sports there. AFCON, it's all getting said, but unfortunately, Osimhen's Balogun's absence rattles Iguavoin. Oh boy. Well, we hope that it turns out well for us. That's Vanguard today.
Nigerian Tribune has the same Magodo Estate standoff on its front page, big and bold. And it even has a picture of the governor. Well, let's first of all take the headline. CSP sent by IGP, AGF refuses Sanwo-Olu's directive and says governor to meet affected parties for peaceful resolution today. It's a very interesting angle to take the story from. And even the picture seems to say a lot. But what you have there is the governor speaking with CSP Abimbola, head of the team sent by IGP from Abuja at Magodo Estate, Lagos. And of course, the Attorney General of the state is also there with him. Right under the picture, Gazette affirming bandits as terrorists out soon. Malami, FG to deploy Super Tucano against bandits and terrorists, he says. Public interest will determine Kano's release. Show evidence you killed bandits. Gumi challenges military. Do you hear that? Very interesting. Well, the details you find on the inside pages
Is this
of the
saying that
papers.
it's not true?
Well, as you said, the devil is in the details. On the back page, AFCON, Iheanacho arrives, 23 Eagles now in camp. And there's this other one, 5 players contracted COVID-19, ascribed to Pinnick. Find the details on the back page of the Nigerian Tribune this morning.
So, we'll take a look at our new Telegraph next. Investigation. FG yet to gazette Islamic group's proscription. It's worrisome. It didn't take time to gazette IPOB in 2017, says Ejiofor. FG to declare bandits terrorists, Malami. Says public interests will determine request for Kano's release. Oh. Public interest matters these days, doesn't it? Oh, okay. And then at the bottom strip, you see convention. APC governors move against CECPC. Lobby state chairman to reject planned shifts. Committee meets with Buhari Friday. Okay. Oh, look at this study. It might help. Garlic can reduce body's cholesterol absorption. So, I mean, some people may say they already know all of this. And then they say Uzodinma recants, fails to name shame sponsors of insecurity in Imo. And then above this lead story, budgets. Aso Rock Gymnasium, others to gulp 7.71 billion naira. And it goes on. So just go ahead and see whichever one you like to pick. That is it with a look at some of the dailies here today. We will be back in a moment.
It's an issue begging for urgent attention, the financial autonomy of the judiciary. So much so that Judiciary Staff Union of Nigeria, JUSUN, took matters into their hands when on April 6 they embarked on a nationwide strike. A strike which not only paralyzed the justice sector, but also resulted in extended prison remands for awaiting trial inmates, prison congestion, lengthier delays of court hearings suffered by litigants and lawyers, and of course the loss of pay for some lawyers. The Chief Justice of Nigeria and the leadership of the Nigerian Bar Association intervened, and eventually the strike was called off on June 9.
As long as the judiciary has to go cap in hand, begging, acting like a parastatal instead of an arm of government that should have its own budget, its own, that's where we're going to be.
Another issue which chilled the judiciary in 2021 and generated public outcry was the embarrassing and indiscriminate granting of conflicting court orders by some judges. Again, the CJN and the NBA intervened. In the end, the National Judicial Council barred 3 judges from promotion to a higher bench for a period of 2 to 5 years.
An appropriate punishment would have been asking them to retire.
The various panels set up by most of the states during the NSAS protest to investigate the alleged atrocities committed by men of the disbanded Special Anti-Robbery Squad submitted their reports in 2021. One low moment, however, was the controversy which trailed the report submitted by the Lagos State Judicial Panel, which probed the October 20, 2020 shooting of NSAS protesters at the Lekki toll gate. But perhaps the most controversial incident in the year 2021 was the invasion of the Abuja residence of the second most senior justice of the Supreme Court, Justice Mary Odili. What made the incident very controversial was that all security agencies in the country, including the Attorney General of the Federation, denied involvement. But following public backlash and the outcry from concerned stakeholders, the police launched an investigation which has now resulted in 15 suspects being arraigned in court.
I must make it known to all understanding that we have had rough dosage of such embarrassments and harassments of our judicial officers across the country, and we can no longer take any of such shenanigans.
On the bright side, as part of measures to eliminate delays and decongest the correctional centers across the country, the Federal Ministry of Justice unveiled a technology for court reporting and a virtual court-sitting facility at the Kuje Correctional Center in Abuja. In year 2021, the courts concluded major cases and handed down jail terms to a former federal lawmaker, Farouk Lawan, a former chairman of the defunct pension reform tax team, Abdurrashid Maina, and his son, a former bank PHB boss, Francis Atuche, amongst others. It was a different story for Shiite leader Ibrahim El-Zakzaki, his wife Zina, and the former governor of Abia State, Orjiu Zokalu, as they got some reprieve from the courts. The court also barred federal government-owned marriage registries, except Ikoyi and the Federal Capital Territory, Abuja, from further contracting marriages under the Marriage Act of 2004. 2022 promises to be busy for the courts. Notable cases to look forward to include the trial of the leader of the indigenous people of Biafra, Nnamdi Kanu, the trial of alleged serial kidnapper, Evans, the trial of Chidima Ojukwu, the judicial dispute between some states and the federal government over the collection of the value-added tax, the suit by the attorneys general of the 36 states against the federal government over the alleged failure to remit funds generated from stamp duties into state accounts, the suits to compel the federal government to account for looted funds so far recovered since 2015, as well as judgment in the suit filed by the states on the funding of the judiciary. The expectation is that the judiciary in 2022 will deliver justice faster and fairly, as well as introduce reform that will shore up its reputation and regain public trust and confidence. Shola Shieli, Channels Television News.
Welcome back. Well, yes, those two gentlemen, Mr. Kehinde Eleja, Senior Advocate of Nigeria, as well as Comrade Emmanuel Abioye, who is the Deputy President, Judiciary Staff Union of Nigeria, Judicial, both join us this morning to weigh in on this subject matter. Gentlemen, good morning, and thank you for joining us on the program today.
Good morning. Thank you.
Good morning. It's my pleasure to be here.
All right, let's start with you, Mr. Eleja. Now, what a year it was actually for the judiciary, but I know that there will always be perspectives for that matter. So for you, what kind of year was it for the judiciary?
Well, thank you. Yeah, 2021 for me was a very challenging year for the Nigerian judiciary. The COVID-19 pandemic, which spilled to year 2021, undoubtedly affected the operations of the court and did not allow the court to perform at its optimal level. Additionally, the judicial strike embarked upon by the Judiciary Staff Workers Union of Nigeria, which lasted about 2 months, did not also help a matter. With these two factors, the judiciary couldn't perform optimally, and of course, it created a kind of a vacuum. Though this is not to say that the judiciary did not fare well, as they had been related in the course of the background information there. So many landmark judgments were delivered by the courts, and of course, the courts were able to discredit themselves well. Notwithstanding the challenge.
So what then do we make of that Supreme Court position that, between the Attorney General of Lagos and Attorney General of the Federation, that the courts could hold virtual seating when it had to do with COVID? Didn't that have some sort of impact? Because you say that impacted negatively COVID on the judiciary.
Thank you. You discovered that decision did not come in good time. And even when it came, many of the courts in Nigeria were not prepared to catch up with the challenges. You appreciate that the facilities will have to be put in place, even in places where you have network. In several places in this country, is either there is an outright network or you had network challenge. So it took time before the courts could adjust to this novel situation. And even at that, there were arguments as to whether the Supreme Court actually made that pronouncement or whether it was a mere obiter. Some courts were skeptical. They wanted to exercise a caution so that their proceedings are not pronounced a nullity at the end of the day.
So could you tell us, what is the current situation regarding that matter now? Have courts adjusted? Do they plan to adjust? Because who knows? We could have another scenario like this in the future.
Well, the good thing about it is that most of the courts have responded. For example, in the new Court of Appeal rules, there is now express provision for virtual sitting of the courts. Many state high courts have also moved in that direction, so that it is beyond argument now that the courts can sit virtually. And even many of the courts have responded to the situation. The Supreme Court, of course, the National Industrial Court, even the Federal High Court. The challenges we are having mainly is with the state, some state courts, and it's understandable, probably because of the issue of lack of independence, and they have in terms of financial autonomy. I think this is also a serious factor that needs to be addressed if the option of virtual sitting will be optimized.
Well, just before we talk to the Judicial Deputy President here, you said that the Judicial strike was significant. Could it have been avoided?
Well, I think it could have been avoided because it was a needless situation that was created by the executive arms in the various states. You agree with me that for quite some time, the federal judiciary, the courts directly under the federal government, had been enjoying some measure of autonomy in terms of their finances. But most states, notwithstanding the express provisions of Section 1213 of the Constitution, which says that their money should be charged directly and be made available to them on the consolidation account. most state courts fail to, most state chief executives fail to give effect to the provisions of the Constitution. And of course, the federal government, through the president, went a step further by enacting Executive Order 10, which was intended to remedy the situation. Unfortunately, this did not achieve the desired impact. So it took the strike of the Judicial to kickstart the process for some of the states to start looking inward, and some of them now have passed their judicial autonomy law. So it was the strike of the Judicial. Of course, one cannot say it was baseless. Of course, there were justifications for it. But in a decent situation, it was avoidable if the chief executives of the state, who are the sworn to uphold the provisions of the Constitution, had kept to their oath of office and allowed the state judiciaries to enjoy their independence.
Mr. Leja, you spoke to the difference between the judiciary at the federal level and at the states. We'll come to that subsequently. But Comrade Abioye, in terms of your assessment of the performance or activities of the judiciary in the year 2021, from the judiciary staff's perspective, what would be your take?
Well, thank you very much. For us in the judiciary, of course, is one house. And I can say that not because I work there, we perform excellently well. So, I mean, when it comes to performance, of course, it's better to be rated by people who are outside the, institution. But definitely, like the Learning 6 said, I mean, judiciary did not perform badly, save for the COVID-19 pandemic and crisis that we all witnessed in the country. So judiciary performed fairly well.
Well, if the judiciary performed fairly well, I'm wondering how come Justin had to go on strike at some point.
Yes, you see, the truth of the matter is when you're talking about the activities of the judiciary itself, I mean, we perform optimally to the best of our ability. So the crux of the bane of our problems is the lack of financial independence, which, of course, it is already in the public domain. So we did our best possible. And one of the things that we did, which can be adjudged as a landmark step we took last year, was the strike. Although it is avoidable, like the Learning 6 said, but notwithstanding, I mean, we had to take the bull by its horn by going on strike. It's avoidable. So for us to make a statement, we for the first time, I mean, we made that statement that it cannot continue to be like that. We cannot continue to go cap in hand to the executive arm of government to ask for what belongs to us. So, I mean, when it comes to the activities of the judiciary, that was the first time ever, although unfortunately it affected so many people. We were not happy going on strike, so it affected us as well. So, but, I mean, for the first time, last year was the time we took the bull by its horn. Going on that strike, it was very necessary for us to make that statement so that it will send the signal to the appropriate quarters that, look, it cannot continue to be business as usual.
So how far with that particular issue that took Justin on strike? Has that issue been resolved?
No, not at all. I mean, not at all. Like Learning 6 said, of course, we did all we could to make sure that we achieve the financial independence, not even as at last year. This struggle has started a long time ago. And you may know that we went to court to institute action against all the state governors and the attorney generals. So, but however, unfortunately, I mean, the judgment of court of competent jurisdiction that was delivered on January 13, 2014 was not obeyed. So, I mean, it's unfortunate that up to now, that judgment had not been appealed against, and yet it was never implemented. There was no compliance to that judgment. And, I mean, further to that, we see that, okay, what do we do next? The best thing for us to do is to go on strike and to make that statement. So far, so good. Nothing much has been achieved. And you recall that there was an agreement, MOA, that was signed between the Governors Forum and our union. And that's to the extent that by the time we suspended the strike, that they were going to take necessary action of promulgating the fund management law at the state level. So up to now, we could only say that maybe like 3 states or so claim to have promulgated that law in their state. But yet, what ought to have followed up, which is the setting up of the fund management team, so that one has not been achieved up to now. So nothing has been achieved so far. So good.
So
Yes.
it then goes to, necessitates asking again, how would you say that judiciary performed fairly well when the enablement, which is the financial autonomy that you talked about, has not really been achieved?
We see, the truth of the matter is, it is not within, we are not the one to determine. We can only say what we have capacity or power to do, which if I say we have not performed well, I'm not being honest and I'm not being fair to ourselves, to the institution itself. So we perform to the extent of the ability that we have,
But it's not about being fair, really. It's just about stating what it is.
Yes, we
That's all.
perform well. So when you are talking about, for instance, we can't take responsibility for somebody else's action. So I can't take, judiciary cannot take responsibility for the non-performance of a particular arm of government. We're not the one to give ourselves money, for instance. So the performance in terms of activities of the institution itself, fairly well. But when it comes to, I think, in my own opinion, the best question, that question particularly, ought to be asked to be thrown to the executive arm of government.
Okay.
Yes.
Well, one of the issues that the SAN raised earlier is that of technology, which Chamberlain asked him. How open are judiciary staff to the inclusion of technology or use of technology in the activities of the judiciary? Are you, by any chance, threatened that there could be job losses?
No, not at all. We're not. The world itself is going digital now. So, obviously, for instance, we have taken that step a long time ago, especially in Lagos State. So the issue of judiciary information system, arguably started from Lagos State, for instance. So we are not threatened by any way that the judiciary is going digital in that way, because it makes the job easier. It makes people to have access to justice the more. So, you can't, for instance, necessarily compare people who are not within the jurisdiction to physically be present before you can now make decision in the court. So it's okay for us. We're not threatened by it at all.
All right, let me take this to Mr. Ledger. Do you subscribe to the school of thought saying that the judiciary may not or cannot do more than they're doing now without addressing the question of financial autonomy?
I agree perfectly with you, because when you talk in terms of performance, it has to be in relative terms. What are the facilities that are made available? You need to go to some of the states and see the appalling state of infrastructures. You see dilapidated courtrooms. Judges are not properly, they are not well treated as they ought to be treated. In many instances, judges are appointed without official accommodation. And even the support staff of judiciary who require to be trained from time to time in tune with modern trends are not trained, basically because in most of the states, the reality is that the chief judges, they go cap in hand to appeal to the executive, to the governors for funds to be allocated. And when such funds are allocated, they are so bigger that they are hardly able to achieve any meaningful result. So a major prerequisite for optimal performance of judiciary, therefore, will be to have full autonomy for the state the judiciaries. It is not even sufficient that we have laws in place, this autonomy law and the rest of it. What is expected is to give them full autonomy, make sure that the money meant for them, the respective appropriation bills, are allocated to them. Let them have full control over these resources. They know what is of utmost importance to them. For example, we are talking about the issue of technology now. In the time past, in some states, attempts were made to digitize the courts and introduce electronic recording. But what happened eventually was that very irrelevant, outdated equipment, technology were brought in, which turned out to be useless to the courts. Whereas if the state the state judiciaries enjoy full autonomy, of course they will be able to determine what their need is, and they will be held accountable in case they fail to meet the expectations of the society from them. So I think you are right.
So how is the question of judicial autonomy, financial autonomy going to address concerns that was raised last time about forum shopping, and then you have people complain about quality of judgments that they see? So how is that going to have direct impact on these kind of issues?
You see, we are talking of multivarious challenges confronting the judiciary. Part of it has to do with issue of appointment of judges. If you look at it, you discover the current situation appears not too good enough. In many instances, you do not even know that the process for appointment of judges had been kick-started. All you realize is to read on the pages of newspapers or in the electronic media that so person had been appointed. So one would prefer a situation whereby the procedure will be made more transparent, just like it is done for aspirants for the rank of Senior Advocate of Nigeria. Let the names of prospective judges be advertised. People should be invited to make comments on their suitability in terms of their character, integrity, and in terms of competence. And I believe if that is done, of course, it's going to be a different ballgame altogether. Even though this is not directly related to the issue of autonomy at national level. But at the state level, it impacts on it. Because here is a state in which the governor controls the resources that will go to the judiciary. And of course, some of these governors see judicial appointments as political patronage to their supporters, to their sympathizers. All they have to do is just to call the chief judge and say, oh, I want so person to be appointed. And if such appointment is made, they just give them something like a great gift. We'll do this for you, we'll do that for you. Because of need, sometimes, some of the state chief judges may not be able to say no. So in a way, it also impacts on the issue of the quality of the appointment of the judges, especially at the state level. Even though at the federal level, it has little or no, it plays little or no role.
Does the bar have, or can they have any role to play in stemming all of this?
Well, the role assigned to the bar under the current setting is not what one would expect. For example, under the current dispensation, the NBA president and some the nominees of the NBA are appointed into the NJC, which is the body that does the ultimate appointment. But at that level, so many procedures will have been passed. For example, nominations will have been done. The prospective judges will have been screened and recommended from their respective states. So the involvement of lawyers who are members of the NJC is just to ratify. And of course, once you have recommendation to say, so person is qualified, and because the procedure has not been made too transparent, it's difficult for them to make a much impact. So I think the bar ought to be given more room. The recommendation of somebody who is aspiring to be a judge, the recommendation of the bar ought to be taken very seriously, so that if the bar says, oh, this person in our view is qualified and we give our reasons, he's taken as such. If you say he's not qualified for so and so reason, then they should be taken serious. This is especially so because as lawyers, we know ourselves very well. It's either we have practiced together at some point, we have appeared before some in the lower courts who are aspiring to become high court judges, or we have had very critical things about them. So I think the bar ought to be given more role right from the commencement of the process, and not at the level of the NJC, where all they do there is just to ratify appointment process that had been kick-started at the state level.
Well, one wonders what role the body of SANs might also be able to play in that regard. But for you, how significant are these issues in the administration of justice? There are those who would say, look, at the end of the day, we've had all of these cases going on, all of these particular issues you're raising going on for so long, and it's still the way it is. Who is supposed to take the lead in ensuring that some of these issues are at least considered, even if not, significantly implemented?
Well, given the prevailing circumstances and the state of the law, I think the VA is doing its best. All it could do now is to call attention and do all whatnot of the state of the law. The VA is somehow handicapped. The role the VA cannot play more than the role assigned to it by the law. That is the truth. But of course, when we talk of this appointment process, it has far-reaching implication on the dispensation of justice. One, a judge who is not competent, or a judge who is wanting in character, is a potential disaster to the system. Because if you have a judge who is not competent, if the ability to dispense justice in accordance with the laid-down procedure is impaired. Of course, because of incompetence, the process is also unnecessarily slowed down. Then when you talk of lack of integrity, it's a big problem. It means that people may not get justice from such court. Let me make this point clear that the observation about some of these heresies is in relation to only very few of the appointments made. That's the truth. Most of the appointments made so far are good, but some people have raised questions in certain instances, and as the practitioner, you also appear before some judges, and the kind of expectation you have pertaining to a judge of the superior court is not met. So that is the way it is. The body of senior advocates, unfortunately, have no statutory role to play in the process. It is only the MBA through its representatives on the NJC that have some limited roles to play. So by and large,
yeah, we'll go to break, but we'll return and talk a little more on the administration of justice, the body of senior advocates, and more when we return in just a moment. Join us again. Welcome back to Sunrise Daily. We're taking a look at the judiciary in the last year, even though they have their own calendar year. So how did it play out for them, those who are in the sector themselves, and then what do they think can be done to improve the sector so that, you know what they say about justice not just being done, but to be seen to have been done? That is a very important component. But Mr. Eleja, let me just get this out of the way. When you mentioned the body of senior advocates, what's the essence of that body in the first place? Because there are those who thought that, well, the body had to come together because, well, if care is not taken, the MBA is going to be, I mean, there are a lot of young lawyers who are coming up and they want a big role in the MBA. So the body of senior advocates had to be formed so that, you can have some sort of presence here and there. Could you talk about that?
Well, as the name suggests, the body of senior advocates is a body that is set up to cater for the interest of the profession. And it is also designed to ensure that as senior advocates of Nigeria who are elders in the profession, that things go the way they ought to go. Let me make it clear that the body of senior advocates of Nigeria is not in any rivalry with the NBA. The body appreciates the fact that we are an integral part of the fold of the NBA, but you know that in every profession, there is always room for people to aspire to get to the top. And the conferment of the rank of senior advocate is acknowledged as a sign of excellence, even though in every human institution you can't talk of perfection. So to that extent, it is a body of eminent lawyers who have reached the peak of the profession and who have a lot to offer in the course of ensuring that the administration of justice is better run, and even providing the support for the Nigerian Bar Association, which is the parent body. Of course, it also takes care of the interest of its members, organizing annual dinners, and a few other social functions. So that is the body.
They can do all this. All this can still be done while still being in the NBA and not forming a different body.
You know that hello? Are you with me?
Yes, we can hear you.
Yes. You see, it is not every lawyer who has been called to the bar who is a senior advocate of Nigeria. As a body, we have certain interests that are peculiar to us. For example, we have our annual dinner, which is for senior advocates of Nigeria alone. We also try to contribute money to assist certain causes. So it is not as if all our interests could be totally taken care of by the NBA. So we have interests that are peculiar to us. And even as a body, the voice of the senior advocate of Nigeria is seen as a very serious complementary voice to that of the NBA in any given situation.
Let's also hope that the body of senior advocates can do something about the strike that you said really disrupted things last year, especially the Judicial strike. Do you see that happening again in the year 2022? And how can we stave it off? Especially since the issues have not been rapturously resolved.
Well, that is a very good question. The issues that led to the problem, that led to the strike, are still with us to a very considerable extent. They have not been resolved. So to that extent, one may want to say that there is a possibility of the strike coming up again. My own counsel to Judicial is that we're all stakeholders in the administration of justice sector. And if they went on strike for 2 months and not much had been achieved now, and who are the losers, the litigants, the society, many of our colleagues who could not earn their living in the course of the strike were the main losers. The governors who are responsible for these problems did not lose much. But they didn't lose their sleep, they were going up and down. Especially so because even those who have political cases before the Supreme Court and other courts, such matters were being attended to. So my appeal is that, yes, while it may be said that the reasons are still there, Judicial should look for a way of addressing the issue this time around, so that the administration of justice is not, administration of justice in the country is not brought to a halt like it happened the last time. I also urge them that the emphasis now ought to be concentrated on states that have not taken steps to do the needful in this respect. Because at the federal level, the federal courts, how can anybody be complaining that there is no autonomy there? All the federal courts are enjoying their autonomy, even in some states like Lagos State and probably Rivers and a few other states. You can talk of autonomy in those states. So why then do you now embark on a blanket strike to stifle administration of justice in the entire country? I don't think it's a fair enough a system. In any event, I want to urge the state governors who are yet to key in to please do the needful, because the administration of justice is something that is so important. Illegal detention of people on account of strike is something that cannot be quantified the monetary term. So that is my appeal to the state governors that are yet to key in. That is my appeal to the judiciary staff of Nigeria. They should have a rethink about the modality and even the scope of the strike if they must raising the issue again, if it has to be revisited.
All right, let's bring in Mr. Abioye on this matter, because, I mean, some of the issues that had been raised previously, even before now, was that why did Jusun have to embark on a blanket strike? Because some states were already, adhering to all of those processes. So it was, to them, a fault that Jusun had to embark on a nationwide strike in all the courts in the country.
Yeah, thank you. To the best of my knowledge, no state has complied to the provision of the Constitution 100%. And when it comes to the compliance to the rule of law, you can't say...
so some of them have been, what, 98%?
How can you say, somebody says, nobody, no state.
No, you say 100%?
Yes,
so to what extent have those ones complied, if not 100?
Well, they can speak for themselves anyway, because the Learned Six said some states had complied substantially, perhaps. But to the best of our knowledge...
Do you disagree with that?
I disagree.
But you said they've not complied 100%.
They've not complied 100%.
It means they've complied to some extent.
He didn't say to some extent.
You said 100%.
Yeah, I said for somebody to comply to the rule of law, it has to be 100%. It has to be 100%.
So is this matter about the Executive Order 10, so it's about the rule of law?
I don't want to talk about
the reason why you went on strike.
I don't really want to talk about Order 10. It's in the court already. So I don't want to talk about Order 10. So I want to talk about the Constitution.
Is that not why you went on, part of why you went on strike?
No, not at all. We have been on this for some time. And our argument is based on the Constitution of the Federal Republic of Nigeria, Section 121, subsection 3, Section 81, subsection 3, Section 162, subsection 9. So we don't have issue with issue of Order 10. Before the Order 10 came, the Order 10, like I used to say, is more or less like you, as a teacher, going into the classroom with a cane in your hand.
No.
Do you need it?
How do you mean? Because, the governors argued about that, saying, look, they didn't want that the federal government cannot dip their hands into their own purse and pay directly to
I don't want to comment on
the
Order 10, really. So let me talk about the Constitution, because that was already in court. That don't be decided. The matter is already in court. I don't know whether you're aware. So I don't want to comment on that. But let me talk about the Constitution of the Federal Republic of Nigeria, which is the grand norm, and upon which the democracy is said to be established. So if you say that, okay, the 100% compliance make an executive arm of government to be functioning, so why not allow the 100% compliance to the Constitution to also allow the other arms of government to operate? How will you say that, for me, 100% I comply with the Constitution of the Federal because it pays me? Okay. And other arm of government, I can reduce the percentage by which I can comply to the Constitution. So
help us understand this. As a union,
yes,
when unions go on strike here, we all know and we see that whatever they ask for, they don't get 100%. So in this case, you're saying that whatever you went on strike for has got to be done 100%.
This particular case is a different case entirely. This is the first time in the history of this country, I stand to be corrected, that a union will go on strike based on the provision of the Constitution. So it has also been a matter of welfareism for our union members and all and all. So our own take is that the Constitution of the Federal Republic of Nigeria, we are citizens of this country. We are not only fighting for our own welfareism. It's for the entire, members of the society. So it has to be 100%. When it comes to the compliance to the Constitution of the Federal Republic of Nigeria, you can't select parts of to comply with the other parts.
So what part of the Constitution have not been 100%? What's the balance that's not been complied with? The Learned Silk, as you called him, cited Lagos and River State as having substantially complied with some of these things that you're talking about. So what are the shortfalls that they have not done?
Well, it is subject to be proven, by whoever asserts that. The assertion was that some states, he mentioned that. So it has to be brought to fore, how they're going to substantiate that. So, but for me, in the union, at national level, the report we got, because we got the report from all the states, we have chairmen in all the states. So, and they gave us the report that no state has complied 100%.
That's why I'm asking.
Yes.
To what extent? What are the things that have not been complied with?
Okay, thank you. let me talk about the current procedure now that have been laid down for the compliance. Because they were saying when we went on strike, part of the arguments of the governors forum was that there was no process of compliance in place, for the provision of the Constitution to be totally obeyed. Okay, we said, fine. And we have Chief Conciliator in person of the Minister for Employment who waded in, and then we all sat together and we made MOA, Memorandum of Understanding of Action, rather, sorry. So, and from that point, there are some provisions that we jointly agreed upon, the process of compliance.
But you haven't answered the question, comrade.
Yes.
What are the specific things that maybe a Lagos or a Rivers that the Learned Silk cited have not been complied with?
Okay, fine,
Just
thank you.
in specifics.
Thank you. For instance, capital projects, execution of capital projects. So part of the budgetary preparation is current expenditure, capital expenditure, recurrent expenditure, and all that in the budget provision. And then when they make budget like that for the judiciary, and of course, you release part of the money meant for the recurrent expenditure, you don't release the one for the capital expenditure. You want to execute the projects for them.
Oh, so the judiciary now wants to be executing
Exactly.
capital projects.
Obviously.
Which is what the governor said, well, no, you can't be carrying out capital projects because that is not the judiciary's function. That's what some of them argue. But Justin says no. They have to have capital project carried out.
Exactly.
But does the National Assembly carry out capital projects?
I mean, I can't speak for National Assembly.
Anyway,
So
that is taken away. Mr. Leja, it's an election year. It's a political year. Okay, just before we sign up, because we have to take that out. We have had, you know the history of the judiciary when it comes to our politics and all of that. And in this year, preceding the year of the election, February 2023, what are your expectations of how the judiciary should comport itself? We have heard sundry injunctions and counter-injunctions and ex parte orders and counter-ex parte orders, all of that. So how do you propose or project that the judiciary should handle its business in this year in a way that it helps democracy to grow?
Well, thank you. In terms of comportment, my expectation is that honorable men and women on the bench should appreciate that many of the judges who have had problems, disciplinary issues in this country, such problems have had to do with the issue of political matters. When you take the percentage of judges who had been sanctioned one way or the other, you discover that most of them arose from political matters. And of course, the recent sanction on 3 judges from Cross River, Rivers, and one from one of the Northwest states also has to do with the political matter. So my expectation is that they should be very careful. They should realize the importance of the offices that they occupy so that they do not do anything to truncate the system. That is one. Then, because by the nature of the political matters, many of them are time-bound, this should be borne in mind so that they are promptly attended to. Importantly, too, I think there should be appropriate case management by the courts, and I think this should emanate from the heads of the court, so that political cases do not suffocate other cases that are equally important, that are pending before the court. Judges who handle political matters should bear this in mind. And I think the heads of courts who will do assignment of cases should also bear that in mind. Well, I think one issue which we really have to address is to revisit the Constitution pertaining to these pre-election matters. You discover that even in substantive election matters, that's talking about the after conduct of election petitions, certain categories of matters do not go beyond the Court of Appeal level. I'm talking of the legislative houses results, State House of Assembly, National Assembly. They terminate at the Court of Appeal level. That is talking even about substantive election. How does one then rationalize the fact that you allow these matters by way of pre-election to get to the Supreme Court? I see that as an aberration. And I think it's a serious clog on the work of the Supreme Court and other courts. Even our colleagues too, I will have to appeal to them that we should avoid doing anything that could undermine the workings of the court, especially in the course of these political matters. After all, cases that were filed in different courts, which resulted into contrary and contradictory interim orders being granted, were filed by certain lawyers. I believe in appreciation of dependency of, or in appreciation of earlier orders and decisions of certain courts. It is not expected. It is not good for the system. And I think as lawyers, we should desist from it. And I think the NBA should also look into that direction so that appropriate report could be made to the disciplinary committee of the legal practitioners of the body of benchers for hearing lawyers to be appropriately sanctioned. This will be my few words for now.
All right, even though many will also be looking to see if there's any iota of truth where they say justice usually goes to the highest bidder, while they also hope to see that, well, cases will not spend decades in court. But I guess we'll look forward to some of these things in the year 2022. But we have to thank you, Mr. Kehinde Eleja, Senior Advocate of Nigeria, as well as yourself, Comrade Emmanuel Abiyo, Deputy President of Judicial. Thank you, gentlemen, for coming on today.
Thank you, my pleasure. Thank you.
In the late 1970s and early 1980s, in this particular case, the land in dispute was said to be owned by indigents who inhabited the area and inherited it from their forefathers, up until when they were allegedly asked to vacate the land by the state government at the time to be used for public purposes. They weren't satisfied and headed to the courts, where they got a Supreme Court judgment in their favor in the year 2012. They want enforcement, and that has led to a face-off. For current residents, they say continuous harassment by security officials who are said to be implementing court orders restoring the land to its original owners is uncalled for and is illegal.
You will recall that we came out on the 21st to protest against the presence of armed policemen in our estates. We came out to protest against the marking by Adeiga and Co. purportedly sent by a group of people to come and take possession of our properties.
The seriousness of the matter, as well as the potential for a breakdown of law and order, has brought Lagos State Governor Babajide Sanwo-Olu to the area.
Can you call your superior in Abuja and tell them that the governor is here and I'm the chief security officer and that you don't have any business being in my state right now and that I want you to disengage forthwith from here?
It is not my duty to call because I'm too low to do that, sir.
I'll make 2 phone calls, right? One to the Inspector General of Police. I have spoken with him this morning and he says he knows nothing about the fact that they are still here. Very illegal operation. They have absolutely nothing, and I'm the chief security of the state. Not even with the Inspector General wrote me, and before I said Jack Robinson, his men are here. They're not from the Lagos State Police Command, like you have said, right? They are not from Lagos State Police Command. It says it's coming from Abuja, and I don't know what other interest do they have beyond just keeping peace of the country.
Governor Sanwo-Olu then goes to consult with some authorities before returning to make an announcement.
I've spoken extensively with the Inspector General of Police, the Honorable Attorney General, and we've resolved all of the issues. Tomorrow, we'll be inviting, the representative of the judgment creditors. We have actually started a committee meeting, but I want to invite them again officially to my office tomorrow by 11 o'clock.
Away from the estate, a representative of the original landlords of Shangisha raises the issues that have brought his people to this situation.
In 1985, our houses that were built on the land were demolished by the then military governor of Lagos State, claiming that the area will be used for international hospital and other programs that will benefit the masses. After the demolition, we find out that the area is being laid out and being shared by civil servants and eminent Nigerian citizens.
This is not the first time an attempt aimed at enforcing court orders has been made. On 21st December 2021, an attempt was made to enforce the Supreme Court order of 2012, prompting the Attorney General and Commissioner for Justice in Lagos State, Mayosore Onigbanjo, to issue a statement clarifying that the order being talked about talks about reallocation of 549 plots of land in the area and not repossession of land, which is what the original landowners are doing. All eyes will now be on the meeting of 5th January 2022, where residents of the estate, officers of the Nigerian Police Force, and members of the original Landlords Association of Shangisha are expected to arrive at a mutually beneficial conclusion for all parties.
Also, it appears an end is in sight. I mean, there's going to be a meeting today by 11, as the governor did say. But to look at some of these matters from a legal perspective, we've got Mr. Additional Ogunlano, who is a former chair of MBA Ikeja branch. Thank you for coming on this morning.
Good morning, gentlemen.
Wow. It does appear that there seems to be a lot more to this matter than what is being seen at the moment. But having looked at this case, listened to the AG of Lagos, the governor, the residents, those who went to court, what's your impression of what is going on?
Thank you so much. The impression of what's going on has only reinforced the position of my organization, the Radical Agenda Movement in the MBA, Ramimba, that Nigeria is a jungle. It may be impolite, that may not be a delicate language, but that's the stark truth. Nigeria is a jungle. A jungle is a place where might is right. And right is not determined by law, legality, legalism, constitutionalism. It's just by muzzle.
Well, how does that play out here? Because they said they're enforcing a court judgment for which they've been in court for a while, yes. And that's the basis of this back and forth, is on a legal basis. So wherein then does
that's what I'm telling you. If it were not a jungle, how will it be a matter that a case will go traverse all the way from the High Court, Court of Appeal, Supreme Court, and then yet to execute becomes a difficulty? Why must that situation even arise in the first instance? I think it was this studio that mentioned the issue of the higgledy-piggledy situation of the man with the knock knee. You see, when somebody with a knock knee is carrying a load, according to the observation of my forefathers, they will say, this gentleman, why is your load like this? Well, you are looking up, you are not looking down. If you look down, you understand. The foundation of the problem is rascality, executive lawlessness, executive impunity, emasculation of the judiciary. That's what's playing out. And it's the fact that you have a situation of a standoff, of a face-off at Magodo. It's only because it's a clash of the titans.
How is there an emasculation of the judiciary here?
Is it not clear?
Tell us
It's
how.
clear. How do you emasculate the judiciary? There's a court order. If there's a court order, you are supposed to ordinarily even give obedience to it. But is that what we do? Is that what we do in Nigeria? Is that what the authorities, the greatest lawbreakers in Nigeria, are the people in government? So you have a situation. We are talking about the Supreme Court. If there was a story that we used to tell us at the law school those days, that was it a magistrate that ordered the commissioner of police in 1972, or Dauphin Bello or so, to come down, to come and appear, and he came immediately. There was a high court judge who gave another to Adamu Shiroma, the then commissioner for finance, etc. about something. They were at a meeting of the Supreme Military Council on that one. He came down.
Okay.
So, but these things have changed. Yeah, so.
Did you listen to the response of the Attorney General of Lagos about what those who are said to have been judgment creditors, how they are going about it?
Yes, I listened to him. Essentially, what he was saying is that the order they were talking about, that is about reallocation, resettlement to some other place, and not repossession as they are touting. I chose to accept that statement by the Honorable Attorney General, Mr. Muisoro Nigbanjo, with a pinch of salt, because he's serving our government. I want to talk of this government. I'm talking of Lagos State government now, being a continuum.
Did you see the judgment?
No, I've not seen the judgment.
So
Just a minute.
Why would you accept it with a pinch of salt?
Why not? And that's the reason I want to give you. That look, Lagos State government is involved in this issue. In fact, it's the principal confucianist. You took people's land wrongly. You took it purportedly to serve the public good. But what you do, and what they have been doing in other places in Lagos State.
Let's stay with this particular one, so that I don't know what they've been doing.
No,
elsewhere.
I think you're unduly editing me, because if you want to lay a foundation, I'll give an explanation. You don't want me to go to that. You want me to just to confirm. If you want me to confirm
what we're
to
discussing
yourself,
is the Magodo estate standoff.
Yes.
And you want to talk about what they've been doing elsewhere. I don't know what they've been doing elsewhere. There's no court judgment of what they've been doing elsewhere.
Let me tell
you cannot
something.
talk about what they've been doing elsewhere that we don't know of.
Let me tell you something. If you say...
That's what we invited you here to discuss, by the way.
Just a minute. If you say, and you're being very sincere, that you don't know, the only thing you know about issues of land and conflict of interest in Lagos State about Magodo, that's okay. I'm not going to quarrel with you about that. But I don't believe you too. But let me just say this. Issue of Magodo, in the issue of... I don't want to go to Magodo again.
No, Mr. Golana, I think we should make it a lot more civil. You were invited to discuss the Magodo estate standoff. So we're discussing the legal provisions before us, the judgment creditors and the position of Lagos State. That is what we're focusing on. So I don't know how you come about wanting to edit you. That is far from the case.
Oh, so I should be constrained to a narrow pool. Thank God you say I was invited. I didn't post myself. So don't make it as if you are doing me a favor. And I want to say this. There is no way you can say somebody wants to make explanation and you are now saying what is... Except it's been excessive. I've not even... About 3 times now I want to make explanation. Even before I delve into it, you've acted the oracle by understanding what I've not even said.
My apologies, Mr. Ogundano.
It's okay.
Let's look at the issues. There are 3 heads in this issue, as it would seem.
Yes.
The Lagos State government is, you have identified the Lagos State government.
Yes.
The Magodo residents themselves,
yes,
they are a head.
Yes.
And then the Shangisha Landlords Association,
yes,
they are a head.
Yes.
Who is the victim here? Or who are the victims here?
Both of them. The people who owned the land customarily before and was taken out, and the people who allocated land by government. Because if you buy land from government, you are supposed to ordinarily be assured. That because, what can be more legal than government. I mean, that if you are located land by government, it is not a money level. Okay. This is not a private something, it's government. So ordinarily, presumption of regularity, everything is in your favor. Okay. And I mean, what else do you need? Okay. I mean, what assurance do you need? Then, unfortunately, now, your otherwise strong interest, I mean, almost unassailable, ordinarily unassailable interest in the land. Somebody has gone to court, and then the Supreme Court is now saying the government that gave it to you was wrong. So now, and you've built. It's not even now maybe vacant possession. You've been living there. Magodo Estate, whether phase 1, phase 2 of Shangisha, it's been more than 20, 25 years. It's been built, you've been living there and all that. Some people have resold and all that kind of a thing. And then somebody now comes up to say, I have a Supreme Court judgment and I want to take the land. You are perplexed.
Well, if I could read out the comments of part of what the judgment, the Attorney General was reading. He says that the judgment read, quote, a declaration that members of the Shangisha Landlords Association whose lands and or buildings at Shangisha Village were demolished by the Lagos State government and or its servants or agents during the period of June 1984 to May 1985 are entitled to the first choice preferential treatment by the Lagos State government before any other persons in the allocation or reallocation of plots in Shangisha Village. And I make the order against the first, second, third, and fourth defendants, particularly the Lagos State government and Land Use and Allocation Committee, as agreed in the meeting held on 16th October 1984 with the Ministry of Lands and Housing and Development Matters. Now, if this is what the judgment says, that's right, they're arguing that what the landlords are going to do is repossession, which the judgment they didn't give. So that appears to be the bone of contention. Or is the repossession and this the same thing?
If you know exactly, repossession, reallocation, talking law, talking technically, are not exactly the same thing. Okay. But if you look at the wording, the way it's worded, I mean, without even looking at extraneous something, it will suggest, it begins to suggest that reallocation did not, unlike what the Honorable Attorney General was mentioning, reallocated somewhere else. I'm just taking what you have just read now and trying to interpret it quite very sincerely. It will begin to suggest to me that reallocation is in that place. It didn't mention any other place. I wouldn't know how it is couched, and I wouldn't know the latest, because what one have to be very sure of is, for example, this particular thing, maybe the landlord, just Shangisha people, ought to have been asked to react specifically to the understanding of that, and I'm talking of Attorney General as Lagos State government. Chris is the chief law officer. So I'll take it as the position of the Lagos State government, their own understanding. Now, are these people now saying, because going from this one, it didn't say outside of Shangisha. Does it mean, is there any still land that you could say you could get up to 545 plots of land in this Shangisha? I don't know the expanse of land. You understand? And like I was saying before he read that thing out, look at these other people too, these owners of land. For you to understand how land and property is to Africans, yeah, I hope I will not be outside. I'm going outside. You see, it's a psychological thing for us. When you have an ordinary accommodation, any seasoned lawyer will know that landlord-tenancy matter, often you cannot solve it by law. Ordinary landlord-tenant, because the African attach a lot of things to where he lives. But not to talk of land.
Yeah, but those are sentiments, and rightly so. But then I don't know how sentimental the law is.
Now, well, let me say this. Law is not sentimental. But there are many schools of thought, jurisprudence about law. You have the realist, you have the positivist, and then you have what you call the social jurisprudence. Law cannot exclude the morality of the people, cannot exclude the psyche of the people. For example, if there's a law now in Lagos State House of Assembly to the effect that when you wake up in the morning, parents should prostrate, Yoruba parents should prostrate to their children, it will fail. It is the law. So if you ask a positivist, we say, that's the law. That I will now prostrate to my child is the law. But will it happen? It doesn't. Okay, look at the law about not spraying money and all that. How many people have been arrested? How many people have been... Because it does not... It's the law. Okay. In fact, it has sense. But because it's yet to aggregate with the perspectives of the Nigerian, it's not yet been...
But perhaps it's in the communication of the law or those policies and all to the people. But in this case now, I mean, you have said that, you know, the two bodies outside of the Lagos, yes, they are victims. So how this issue will be resolved now? What will be your recommendation? The governor has said in that address, you know, to the press that there's going to be a meeting at 11 a.m. today.
Yes.
So Magodo Residents Association was not joined in any of the cases from the High Court to the Supreme Court in whatsoever manner, shape, or form. And the Shankisha Landlords Association, there has been some measure of resolution with some other heads. But to some others, it's either Shankisha or no other thing. So what are the things, both legally and otherwise, from the perspective that you are looking at?
Thank you so
much. What are the
recommendations
you would consider that should be taken
Let me first appreciate the government of Lagos State, or the governor, of taking the initiative. If it's I think it's been ongoing. It cannot be absolutely new. This idea of calling everybody to come and to a round table and try to trash it out. Now, our people say, if it's a man-made problem, then it's man that will solve it. This is not a spiritual problem. This is a man-made problem. And I want to say that law cannot solve this. Law cannot solve it.
Why?
Because if it were a matter of law solving it, it would have solved it. If you are in a very orderly society, you understand, very orderly society, law will solve it. But when you are in this kind of a society where it is a matter of might, okay, look at the gentleman from Abuja, the policeman from Abuja. I was reading reports and I was laughing. I saw them even dancing. I said, "Where are you? Where are you from?" They say, "Well, we are from Abuja." Malami said he doesn't know about them. Baba Gadim, I think, the IGP said, according to the governor, what we read for the governor, said he's not aware. Now, what? And they're there. And for a CSP, ordinary, a CSP to defy the governor, it's not a new thing. At Tenere, the governor was actually kidnapped by policemen. That's in Gige. Many years ago, Rashid Ladoja was stormed by thugs at the secretariat. As governor of Justice, and police were looking on. A commissioner of police said of Ruth Timamichi that is a leopard, but I will tame him. I'm a lion. I tame him. That's I'm just to show you that the idea of the governor say I'm the chief security officer is in theory. In practice, it's not, because of the kind of system we are operating. In fact, I think the commissioner of police followed the governor. If I'm right, or something. There was a clip I saw. The now newly promoted IG. He was just looking on. What can he do? Because we are, like I said, indelicately, we're in a jungle. So that's why talking law, strictly law, because as your Bible will say, there's no side you ask in the conflict that will not have supposedly cogent reasons. Okay. So now what you do in this kind of situation is to bring the African principle of dispute resolution, which is different from the European way, which is litigation. Litigation is adversarial, it's combative, it's ego. But this one, like if I were to be there, if I have the opportunity to give them advice, it's going to be a give and give situation, win and win situation.
What would it be?
You said,
what would your advice specifically be to all these parties?
That's what I'm going to say. Now, if the truth of the matter is, look at the reality on ground. It has happened, place is built up. place is built up. Somebody was saying, how was Ojora, the issue of Ojora in Edo, and what was it set under Governor Fashola? They got, I mean, 7-Up, giant companies were all over the place and everything. We didn't hear, that's a way. And that's going to be, if I were to give advice, is the Lagos state government that's going to bear a lot of brunt of this settlement. The people, we have to appease to the genuinely aggrieved people. We have to agree. We have to, first of all, if I'm mediating, I would say, let us agree that if indeed the allegation that Lagos state government took your land and did not use for purpose, it's not good, and we are sorry. But it has happened, it has happened. A dead child cannot be brought back to life again. These people now, even they themselves have been 20, 25 years, some of them even bought from other people. Do you want us to, even if they vacate this place today now, if they vacate this place and move out, do you want to inherit the houses, or you want to clear, do you want to clear, you want to bulldoze all this place and all that? Somebody talking like we say, quick plantanto, so said it. Whatever is attached to the land belongs to the owner of the land. But in the reality of our existence, will that be fair? So the very first people to appeal to is these Adega-led people, and not to be berating them as being unreasonable, as being adamant, that even they are able to get to this point, I'm telling you, it's not because of law. It's because of connection. This is the truth. It's the elite conflict. This is the truth. I don't want to be pigeonholed, but this is the truth. There are other places where I see nothing happened. That's why if it's in jungle, you flex muscle, you flex muscle. If you are going on the traffic, you're either a soldier or a lawyer. When the policeman see you, say, about the law, go, soldier, go. But this is under the law. They arrest you.
So the judiciary is for the big boys.
This is the truth. Unfortunately, this is the truth. This is the truth. In theory, everything is okay, every access to justice and everything. But in practice, there are some concessions. When you are big, when you are a big fish in an ocean, there are some things that are given to you on account of your clout. You understand?
I thought the judiciary is supposed to be, doesn't matter who comes before me, this blind justice is blindfolded.
I like your preface. You said supposed, presumed, you know, imagined. But the stark reality.
So the judiciary now wears glasses.
Anyway. More than, okay. But they don't wear blinkers, you know.
Let me. There are other issues that have been thrown up here. Is something that you also referenced earlier, which is the land acquisition right of the state.
Yes.
On the one hand, we say that the governor owns the land in the state. He's the custodian of the land for the whole state. But now we have a case where some landowners have taken government to court and won against the government.
Yes.
So that's an issue that has been raised there. How do you see the law, addressing this issue over time? I asked that against the premise of some of the issues that you were attempting to raise. Today it is Lagos, Magodo. Tomorrow it could be somewhere in Ilorin, it could be at Takumosa in Osun State, it could be anywhere else. What are the things that you would recommend? How would you want this resolved?
Thank you. It comes to the idea of social responsibility. You see, first of all, the governor does not own the land.
Okay.
You understand? He holds it in trust for the people. And when you are a trustee, you are supposed to be fidel, to be responsible, to be judicious, to be fair. You are a trustee. You are not supposed to waste the asset. You are not supposed to be lopsided. You are supposed to be fair. You understand? So, and it's for the purpose of rapid economic development that the Obasanjo government purported, created the land use charge to free it from the stranglehold of traditional customary ownership and all that. So now, when a governor or a government says, I'm acquiring all this, okay, look at where you are now and everything, and somebody comes tomorrow and says that we are acquiring this place because we want to do a giant hospital or something, which is good and everything, and pay you compensation, and if they pay you well, and you just move, only for you to now see tomorrow that is now a private golf resort of one, what the gentleman say, eminent Nigeria. See, the truth of the matter is this. Many eminent Nigerians are actually irresponsible, anti-Nigerian, unpatriotic people out for their own selfish interest. And you are allocating this land. If, for example, if that place, look at how big Magodo is really turned into a truly public facility, not a private empire of small holdings of people. Therefore, people now look at these our people and say, why are you complaining and that kind of a thing? Well, that was not done. So now the question is not there's a conflict. It's the dearth, D-E-R-T-H, dearth of adequate social sense of responsibility. When you've been giving power and trust for people, use it properly according to the law. So the law in Nigeria is theoretical. In practice, it's put to something. Some people go put a lot of pressure on these governors. I want a land. I want that. I'll give you this place.
So does it then mean that that Land Use Act, this might give it a different meaning? Because if government comes and says, well, citing the Land Use Act, that we want to use this space for development, and then you find that, or is it that they have to tell you specifically if they are taking your piece of land, what they want to do?
Yes.
They have to specify.
In fact, the gazettes, by law, by gazette, you know, so that there won't be an issue of rapine, that you just take people as anyhow. It must be, they call it overriding public interest. That's the general language is couched, overriding public interest. If a place is taken from people traditionally holding it or people even bought it and like your own place there, for overriding public interest.
And I see that other people are coming to occupy it.
To occupy it.
So what if to me, this is not overriding public interest?
So you go, yes, the law allows you to go to court to set that acquisition aside. Is the law.
Does that raise any necessity to adjust the land acquisition authority that states have?
No, sir. It is the Nigerian that we need to reset. It's like the issue of the constitution we talk about. Is the issue of the laws, enforcement, and all that. It is how do I put it now? It is the driver. Even if a vehicle is not so good, but the driver is good and let me be careful. There's a way he can still manage for a cranky car. But if a driver is reckless, is irresponsible and everything, even with a very good car and everything, he crashes it.
But if the car is still very good in Lagos, they can still hit you even if you are driving very well.
No, you don't understand. Well, you are talking of external factors now. But it should not be that it is you, the driver, in control of the vehicle that has the problem. So it's the people in levels of governance generally.
Unfortunately, sir, this particular vehicle you are talking about has been driven by so many people over the years, since 1976, 1984.
Even before then now. Before then, and what else I say, but it doesn't mean that because we have been doing it this way, we must continue doing it that way.
Which is why I ask, should we adjust the law?
No, it's not the law. Okay. No, it's not the law. What the law expects you, okay, look at the intent of the law. You take the land from some people and for the benefit of the public, that is Benthamism. Jeremy Bentham, that's the philosopher of the law who says that a law must be for the purpose of the greatest number, the happiness of the greatest number of the people. That's the purpose of the... So if a governor takes over a place, maybe you are 2,000 people that are living there, but I want to use it for the benefit of 5 million people. Of course, that's better and is properly done. Then nobody will query that governor. That's the intent of the land use. So I know there's no way when you make a law absolute without a caveat is going to be abused. Okay. Fortunately, the law is built in with some caveat. And that's the caveat that these people had gone to court to say, no, this is not... just like the issue of arresting of a criminal and everything, criminal suspect. Yes, it's good. You should apprehend somebody who has committed a crime or about to commit a crime. But when you put him in custody, you begin to torture him, you begin to extract things from him. You are now going outside of the law, even though you have the power of arrest and detention, but you are now going outside of this. So that person can go to court to challenge that way you are exercising your power. Okay. That's what has happened in the issue of the Land Use Act, or Land Use Law in Nigeria, where it is land, for example, look at what happened in Ibadan, Lagos, Ibadan way, when, I mean, something was expanded and everything, things were cleared and everything. Nobody will complain about it because they said we want to take your land because we want to expand, which millions of people will use. I mean, that's fair enough.
Okay. Well, I guess lessons are learned. I mean, so if people want to buy land now... Well,
let me quickly say this before I go away, that I hope the meeting of today, I hope it succeeds. But I don't think it's going to be a one-off thing. Real experienced, level-headed, calm people should superintend over this meeting. Our appeal should be made to people to drop their ego, right, left, and center. The issue of our estate, you cannot come and take our land. Then these other people too appeal to you. Look at the reality. If it's a problem caused by human beings, let human beings solve it. It's not demons that cause it. It's human beings.
Okay.
Well, we hope that they can just listen to, take some of this advice and ensure that things are sorted and peace reigns, which is what we want to see everywhere. Actually.
Absolutely.
Well, I want to thank you very much indeed, sir. Mr. Adesina Ogunlana is the legal practitioner and former chairman, Nigerian Bar Association, Ikacha branch. Well, let's take a look at some of your response quickly before we wrap up. Olagunju says about resolving Magodo land disputes. Ignoring a problem makes the problem grow, which is usually the case with Nigeria.
Okay, let me not even say anything about that. Festus says about state police debate. State police is meaningless if there is no investment in human capital development and infrastructure. Many governors only invest in major towns and not interested in investing and opening up the rural areas of their states. Also, without state police, the governors can do more to secure their people with the billions of naira they're getting in security votes. There's nothing stopping governors from having and funding neighborhood watch like Lagos State government.
Well, Effie, still talking about state police in Nigeria, says, I support the idea of state policing and I believe it will aid securing the country. The argument that governors will use them for selfish interests, I think, is not viable because we still have federal police that can come from time to time, check the activities of the state police. They should also give autonomy to local governments so they can be more effective and be held responsible for the failure or success in their territories.
Peter also says about judiciary in 2021, prospects for 2022. I suggest that the Constitution of Nigeria should be taught as a general course in tertiary institutions. The judiciary should ensure this. Every Nigerian who has attained tertiary education should be aware of how the country operates. I thought we had social studies and civics in secondary school.
But not about judiciary in terms of how the law works or what it should be.
All I need to know is my rights. What else is there?
Anyway. Your left. Well, that's the show today. Thank you all for watching. We'll see you tomorrow. I'm Chamberlain. What's up?
I'm Ayo Makide. Have a wonderful day.